2. Homestead. A homestead is a person's primary residence, usually a house or a farm, that is protected from certain creditors' claims by state law. Homestead laws vary by state and provide homeowners with certain legal protections, such as exemptions from forced sale or attachment by creditors in the event of financial hardship or bankruptcy. Homesteads are often considered a person's most valuable asset, and homestead laws are designed to help safeguard a homeowner's primary residence from being seized by creditors to satisfy debts. 3. Homestead exemption. A homestead exemption is a legal provision that allows homeowners to exempt a certain amount of the value of their primary residence from being used to satisfy certain types of creditors' claims. Homestead exemptions are typically provided by state law and vary by state, and they are intended to provide homeowners with a measure of protection against forced sale or attachment of their home by creditors in the event of financial hardship or bankruptcy. The amount of the homestead exemption varies by state and may be subject to certain restrictions and qualifications. 4. Judgment lien. A judgment lien is a legal claim against a person's property, both real and personal, that arises from a court judgment. It is typically filed with the county recorder's office and creates a lien against the property, which serves as notice to potential buyers, lenders, and other interested parties that there is an outstanding judgment against the property owner. Judgment liens are used to enforce court judgments and can be used by creditors to seize and sell the property to satisfy the judgment debt. 5. Mechanics liens. Mechanics liens, also known as construction liens or contractors' liens, are legal claims against a property that arise from unpaid debts owed to contractors, subcontractors, or suppliers for labor, materials, or services provided in connection with construction or improvement of the property. Mechanics liens typically provide a security interest in the property and give the unpaid party the right to enforce the lien by foreclosing on the property and seeking payments from the proceeds of the sale. Mechanics liens are governed by state laws and usually require strict compliance with specific notice and filing requirements. 6. Notice of cessation. A notice of cessation is a legal document that is filed by a contractor or property owner to officially declare the cessation or stoppage of construction or development activities on a property. It is typically filed with the county recorder's office and serves as notice to interested parties, such as subcontractors, suppliers, and potential buyers or lenders, that work has ceased on the property. Notice of cessation may trigger certain legal and contractual rights and responsibilities, such as the expiration of mechanics lien rights, termination of contracts, and changes to project timelines or deadlines. 1. Notice of completion. A notice of completion is a legal document that is filed by a property owner or contractor to officially declare the completion of construction or development activities on a property. It is typically filed with the county recorder's office and serves as notice to interested parties, such as subcontractors, suppliers, and potential buyers or lenders, that the project has been completed. Notice of completion may trigger certain legal and contractual rights and responsibilities, such as the commencement of warranty periods, the expiration of mechanics lien rights, and the release of retention or holdback amounts. 2. Notice of non-responsibility. A notice of non-responsibility is a legal document that is filed by a property owner to formally declare that they are not responsible for the debts or obligations incurred by a contractor or other third party in connection with construction or improvement activities on their property. It is typically filed with the county recorder's office and serves as notice to potential lien claimants, such as subcontractors or suppliers, that the property owner is not liable for any unpaid debts or liens that may arise from the work performed on the property. 3. Preliminary notice. A preliminary notice, also known as a pre-lien notice or a notice to owner, is a written notice that is typically sent by a contractor, subcontractor, or supplier to the property owner, general contractor, and other interested parties to notify them of their involvement in a construction or improvement project. Preliminary notices are usually required by state law and serve as a formal notice of the claimant's right to file a mechanics lien or other legal claims for unpaid debts in the event of non-payment. Preliminary notices typically contain information about the claimant, the work performed, and the amount owed, and they are used to protect the claimant's lien rights. 4. Specific liens. Specific liens are legal claims against a property that are created by a specific event or action, such as a mortgage, a mechanics lien, or a tax lien. Unlike general liens, which attach to all of a person's property, specific liens are limited to a particular property and are typically created to secure the payment of a specific debt or obligation related to that property. Specific liens give the lien holder the right to seize and sell the property to satisfy the debt or obligation in the event of default or non-payment. 5. Stop notice. A stop notice is a written notice that is typically sent by a contractor, subcontractor, or supplier to the property owner, general contractor, and other interested parties to formally request that all construction or improvement activities on a property be stopped until the claimant's unpaid debts or liens are resolved. Stop notices are usually used in conjunction with mechanics liens and are intended to provide additional leverage to the claimant by putting a halt to the construction or improvement activities until the claimant's debts or liens are satisfied or resolved. 6. Tax liens. Tax liens are legal claims against a property that arise from unpaid taxes owed to a government entity, such as a local government or the Internal Revenue Service, IRS. Tax liens typically result from delinquent property taxes, income taxes, or other types of taxes, and they give the government entity the right to seize and sell the property to satisfy the unpaid taxes. Tax liens are typically recorded with the county recorder's office and can take priority over other liens or claims against the property. 1. Verification. In the context of real estate, verification refers to the process of confirming or substantiating the accuracy, truthfulness, or authenticity of information or documents related to a real estate transaction or legal matter. Verification may involve checking the validity of information provided by parties involved in the transaction, such as the buyer, seller, lender, or other stakeholders, to ensure that it is complete, accurate, and in compliance with applicable laws, regulations, or contractual requirements. Verification may also involve obtaining supporting documents, conducting research, or obtaining statements from relevant parties to corroborate or validate information. 2. Writ of execution. A writ of execution is a legal order or document issued by a court that authorizes a sheriff or other authorized officer to enforce a judgment or order of the court by seizing and selling property of the judgment debtor to satisfy a debt or obligation. In the context of real estate, a writ of execution may be used to enforce a judgment related to a real estate transaction, such as a judgment for unpaid debts, liens, or other legal claims against a property. Once a writ of execution is issued and served on the judgment debtor, the authorized officer may proceed with the seizure and sale of the property to satisfy the debt or obligation as specified in the writ. The process of executing a writ of execution is subject to applicable laws, regulations, and procedural requirements, and it may vary depending on the jurisdiction and specific circumstances of the case. Unit 12 Adjacent Property Rights. 1. Abatement. In real estate, abatement refers to the reduction, elimination, or termination of a nuisance, encumbrance, or other undesirable condition that affects a property. Abatement may involve correcting or mitigating a violation of building codes, zoning regulations, or other laws, resolving disputes related to property boundaries or encroachments, or remedying environmental hazards or nuisances that impact the property's value or use. Abatement actions may be initiated by property owners, government agencies, or other stakeholders, and they may be subject to applicable laws, regulations, or legal processes. 2. Accretion. Accretion is a term used in real estate to refer to the gradual and imperceptible buildup of land through natural processes, such as deposition of sediment or soil, erosion, or changes in watercourses. Accretion may occur along rivers, lakes, coastlines, or other bodies of water and may result in the expansion or alteration of property boundaries. In some cases, the owner of the property where accretion occurs may gain additional land as a result of the gradual accumulation of soil or sediment, subject to applicable laws, regulations, or legal principles. 3. Affirmative easement. An affirmative easement is a type of property right that grants a specific individual or entity the right to use or access another person's property for a particular purpose or benefit. The owner of the property subject to the easement, known as the servient estate, is obligated to allow the holder of the easement, known as the dominant estate, to use or access the property in a specified manner, such as for a right-of-way, utility easement, or other permitted use. Affirmative easements are typically created through a written agreement, such as a deed, and they may be subject to applicable laws, regulations, or legal requirements. 4. Avulsion. Avulsion is a term used in real estate to refer to the sudden and abrupt removal or loss of land due to natural or human-induced events, such as a sudden change in a river or stream channel, an earthquake, or a landslide. Unlike accretion, which involves gradual and imperceptible changes to land boundaries, avulsion results in a sudden and noticeable change in land boundaries, and it may affect property ownership or rights. The legal implications of avulsion may vary depending on the jurisdiction and specific circumstances of the event, and they may be subject to applicable laws, regulations, or legal principles. 5. Doctrine of agreed boundaries. The doctrine of agreed boundaries is a legal principle used in real estate to resolve disputes or uncertainties related to property boundaries by mutual agreement of the affected parties. Under this doctrine, neighboring property owners may agree to establish or modify a boundary line between their properties through express or implied consent, acquiescence, or other forms of mutual agreement. Once a boundary line is agreed upon, it may be legally recognized and enforced, subject to applicable laws, regulations, or legal requirements. The doctrine of agreed boundaries may be used to resolve disputes related to encroachments, boundary line disputes, or other issues that affect property ownership or rights. 6. Dominant tenement. In the context of easements, the dominant tenement refers to the property or estate that benefits from an affirmative easement. The owner of the dominant tenement holds the right to use or access the servient estate, which is the property subject to the easement, for a particular purpose or benefit as specified in the easement agreement. The dominant tenement is entitled to exercise the rights granted by the easement, subject to applicable laws, regulations, or legal requirements, and is typically responsible for maintaining or repairing the easement area, unless otherwise specified in the easement agreement. 1. Easement. An easement is a legal right or privilege that grants a person or entity the non-possessory right to use or access a portion of another person's property for a specific purpose. Easements may be created through various means, such as written agreements, express or implied consent, necessity, prescription, estoppel, or other legal principles. Easements can be affirmative, allowing the holder to use the property for a particular purpose, or negative, prohibiting the property owner from doing something that may interfere with the rights of the easement holder. Easements may be subject to applicable laws, regulations, or legal requirements, and they may impact property ownership, use, and rights. 2. Easement by estoppel. An easement by estoppel is a legal doctrine that arises when a property owner makes representations or promises to another person that induce them to rely on such representations or promises and incur expenses or change their position in reliance on them, leading to the creation of an easement. In other words, if a property owner leads someone to believe that they have an easement or right to use their property, and the person relies on such belief to their detriment, the law may recognize an easement by estoppel, even if no formal written agreement or other legal requirements are met. 3. Easement by necessity. An easement by necessity is a legal right that arises by operation of law when a property is landlocked or otherwise lacks access to a public road or other means of ingress or egress. In such cases, the law may recognize an easement by necessity to allow the landlocked property owner to reasonably access their property. Easements by necessity are typically created when the property was previously owned by a common owner and then divided into separate parcels, resulting in one parcel being landlocked. Easements by necessity are subject to applicable laws, regulations, or legal requirements, and they may be terminated or modified under certain circumstances. 4. Easement by prescription. An easement by prescription is a legal right that is acquired through continuous, open, notorious, and adverse use of another person's property for a certain period of time, as prescribed by law. In other words, if a person uses another person's property in a manner that is visible, open, and without permission for a certain number of years, the law may recognize an easement by prescription as a legal right, even if no formal written agreement or other legal requirements are met. Easements by prescription are subject to applicable laws, regulations, or legal requirements, and they may be terminated or modified under certain circumstances. 5. Easement in gross. An easement in gross is a type of easement that is granted to a particular person or entity, rather than being tied to a specific parcel of land. In other words, the easement benefits an individual or entity, rather than a particular property. Easements in gross may be created for various purposes, such as for utility lines, access to a specific resource, or other specific uses. Easements in gross may be subject to applicable laws, regulations, or legal requirements, and they may be terminated, modified, or transferred under certain circumstances. 6. Encroachment. Encroachment refers to the unauthorized or wrongful intrusion or trespass of a structure, improvement, or other object onto the property of another person. Encroachments can occur in various forms, such as buildings, fences, trees, or other objects, and they may infringe upon the legal rights, boundaries, or use of another person's property. Encroachments can result in disputes, legal liabilities, or other legal consequences, and they may be subject to applicable laws, regulations, or legal principles. 1. Implied easement. An implied easement is a type of easement that is created by operation of law, without a formal written agreement, based on the circumstances or actions of the parties involved. Implied easements may arise when there is an apparent or implied intent of the parties to create an easement, and such intent can be inferred from their conduct, relationship, or other relevant factors. Implied easements may be created when there is a necessity, prior use, or other implied understanding between the parties that gives rise to the easement, even if it is not explicitly stated in a written agreement. 2. Lateral support. Lateral support refers to the legal right of a property owner to have their land supported by adjacent land, so as to prevent or minimize subsidence, shifting, or collapse of their property. Lateral support is a common law principle that recognizes the obligation of neighboring property owners to provide adequate support to each other's land, especially when excavation, construction, or other activities may impact the stability or integrity of the land. Lateral support may be subject to applicable laws, regulations, or legal requirements, and disputes over lateral support may be resolved through legal means. 3. License. In real estate, a license is a revocable permission or privilege granted by a property owner to another person, allowing them to use or access the property for a specific purpose, without transferring any ownership or possessory interest in the property. Licenses are typically informal, temporary, and revocable, and they may be granted orally or in writing. Licenses may be created for various purposes, such as allowing someone to enter a property for a specific event, granting permission to park, fish, or hunt on a property, or other limited uses. Licenses are not typically considered as property rights, and they may be subject to applicable laws, regulations, or legal requirements. 4. Literal rights. Literal rights are legal rights that pertain to the ownership, use, and access to land that borders a navigable body of water, such as a lake, sea, or ocean. Literal rights are typically related to the use and enjoyment of the water, and they may include rights such as access to the water, fishing, swimming, boating, and other activities. Literal rights may be subject to applicable laws, regulations, or legal requirements, and they may be limited or restricted based on the location, size, or nature of the body of water. 5. Merger. Merger is a legal doctrine that applies when the separate legal interests in a property are combined or consolidated into a single interest, typically through the actions or intentions of the parties involved. Merger can occur when the owner of both the dominant and servient estates in an easement becomes the same person, resulting in the termination or extinguishment of the easement. Merger may also occur when a property owner acquires both the fee simple title and the leasehold interest in the same property, resulting in the termination or consolidation of the two interests. Merger may be subject to applicable laws, regulations, or legal requirements, and it may have implications for the rights, obligations, or interests of the parties involved. 6. Negative easement. A negative easement is a type of easement that prohibits the owner of the servient estate from doing something on their property that would otherwise be lawful, in order to protect the specific right or interest of the owner of the dominant estate. Negative easements may be created by written agreement or through other legal means, and they typically impose a duty on the owner of the servient estate to refrain from certain activities or uses of their property that may interfere with the rights of the owner of the dominant estate. 1. Nuisance. In real estate, nuisance refers to an unreasonable interference with the use or enjoyment of a property that may be caused by a neighboring property or activity. Nuisance can be either a private nuisance, which affects the use and enjoyment of a specific property, or a public nuisance, which affects the health, safety, or welfare of the general public. Nuisance may be caused by various factors, such as noise, odor, pollution, vibration, or other activities that may disrupt the normal use or enjoyment of a property. Nuisance may be subject to applicable laws, regulations, or legal requirements, and it may give rise to legal claims, disputes, or remedies. 2. Reliction. Reliction is a legal term that refers to the gradual and permanent exposure of land that was previously covered by water due to the recession or withdrawal of water bodies, such as rivers, lakes, or oceans. Reliction typically occurs when the water level decreases over time, revealing new land that was previously submerged. Reliction may result in changes to property boundaries, rights, or interests, and it may be subject to applicable laws, regulations, or legal requirements. 3. Right of correlative use. The right of correlative use is a principle of water law that applies to the use and allocation of water from a shared source, such as a river, lake, or aquifer, among multiple owners or users. The right of correlative use provides that each owner or user is entitled to a reasonable share of the available water, based on their proportionate ownership or use, and subject to the reasonable needs of other owners or users. The right of correlative use may be subject to applicable laws, regulations, or legal requirements, and it may be limited or restricted based on the location, availability, or sustainability of the water source. 4. Right of prior appropriation. The right of prior appropriation is a principle of water law that determines the allocation of water rights based on the principle of first in time, first in right. Under the right of prior appropriation, the first person or entity to beneficially use water from a water source for a specific purpose, such as irrigation, domestic use, or industrial use, acquires a priority or senior right to continue using that water, to the exclusion of subsequent users. The right of prior appropriation may be subject to applicable laws, regulations, or legal requirements, and it may be limited or restricted based on the location, availability, or sustainability of the water source. 5. Riparian rights. Riparian rights are legal rights that pertain to the ownership, use, and access to water that borders or passes through a property, such as a river, stream, or creek. Riparian rights are typically related to the natural flow, quantity, and quality of the water, and they may include rights such as access to the water, fishing, swimming, boating, and other activities. Riparian rights may be subject to applicable laws, regulations, or legal requirements, and they may be limited or restricted based on the location, size, or nature of the water source. 6. Servient tenement. Servient tenement is a legal term that refers to a property or parcel of land that is subject to an easement or other encumbrance in favor of another property or parcel of land, known as the dominant estate. The servient tenement is the property that is burdened or encumbered by the easement, and the owner of the servient tenement is typically obligated to allow the owner of the dominant estate to exercise their rights or interests in the servient tenement, as specified in the easement or other encumbrance. The servient tenement may be subject to applicable laws, regulations, or legal requirements. 1. Spite fence. A spite fence is a tall, unsightly, or offensive fence that is constructed or maintained with the intention of annoying or harassing a neighboring property owner. Spite fences are typically built out of malice or ill will and are intended to obstruct views, block sunlight, or otherwise interfere with the use or enjoyment of a neighboring property. Spite fences may be subject to local ordinances, zoning regulations, or legal requirements, and they may give rise to legal disputes or remedies if they are found to be unreasonable or malicious. 2. Subjacent support. Subjacent support is a legal principle that refers to the right of a property owner to have their land supported by the underlying soil or rock. Subjacent support typically applies to properties that are located in areas with unstable or shifting soil, such as hillsides or areas with underground mines. The principle of subjacent support means that the owner of the land above has the right to expect that their land will be supported by the natural condition of the underlying soil or rock, and neighboring property owners or activities that may cause subsidence or settlement of the land may be liable for damages or compensation. 3. Trespass. Trespass is a legal term that refers to the unauthorized entry, intrusion, or use of someone else's property without their permission or legal right. Trespass may occur by physically entering someone's land, placing objects on their property, or otherwise interfering with the use or enjoyment of their property. Trespass may be intentional or unintentional, and it may be subject to legal claims, disputes, or remedies. In real estate, trespass may involve issues such as encroachment, boundary disputes, or unauthorized use of someone else's property, and it may be subject to local laws, regulations, or legal requirements. Unit 13 Land Use Controls. 1. Aesthetic zoning. Aesthetic zoning refers to the practice of regulating the visual appearance, design, and aesthetics of buildings, structures, or properties through zoning regulations or land use restrictions. Aesthetic zoning may involve requirements for building materials, architectural styles, color schemes, landscaping, or other design elements to ensure that new development or construction is visually compatible with the surrounding environment or neighborhood. Aesthetic zoning is often used to preserve the character, heritage, or unique features of a particular area or community, and it may be subject to local zoning ordinances, design guidelines, or review processes. 2. Alquist-Priolo Special Studies Zone Act. The Alquist-Priolo Special Studies Zone Act is a California state law that is designed to regulate development in areas that are prone to seismic hazards, such as earthquake faults. The act requires the identification and mapping of active fault zones, and it establishes special study zones around these fault zones where certain development restrictions and requirements apply. The Alquist-Priolo Act is intended to reduce the risk of damage or destruction from earthquakes by prohibiting or limiting certain types of development, such as residential or school construction, within specified distances from active fault lines. 3. Bulk zoning. Bulk zoning is a type of zoning regulation that controls the physical dimensions, size, or scale of buildings, structures, or properties, often in relation to the surrounding environment or neighborhood. Bulk zoning typically involves regulations or requirements for setbacks, height limits, lot coverage, floor area ratio, FAR, or other physical characteristics of buildings or properties. Bulk zoning is used to manage the density, massing, or intensity of development in a particular area or zone, and it may be used to promote certain land use objectives, such as preserving open space, maintaining views, or managing congestion. 4. California Environmental Quality Act. The California Environmental Quality Act, CEQA, is a state law that requires public agencies in California to assess and mitigate the environmental impacts of proposed development projects. CEQA mandates the preparation of environmental impact reports, IRs, for projects that may have a significant effect on the environment, and it requires public agencies to consider feasible alternatives, disclose potential impacts, and involve the public in the decision-making process. CEQA is intended to promote environmental protection, public disclosure, and informed decision-making in land use planning and development in California. 5. Coastal Zone Conservation Act. The Coastal Zone Conservation Act is a state law in California that is aimed at protecting and preserving the state's coastal resources, including beaches, wetlands, wildlife habitats, and scenic areas. The Act establishes the California Coastal Commission as the agency responsible for regulating development activities in the coastal zone, and it sets forth policies, regulations, and permit requirements for development projects that may affect the coastal environment or natural resources. The Coastal Zone Conservation Act is intended to balance the need for development with the protection of coastal resources and public access to the coast. 6. Comprehensive zoning. Comprehensive zoning is a type of zoning approach that involves the systematic planning and regulation of land use and development within a specific jurisdiction or area. Comprehensive zoning typically involves the adoption of a comprehensive plan or master plan that sets forth the long-term vision, goals, and policies for land use and development, and it may include regulations or guidelines for zoning districts, permitted uses, density, design standards, or other land use controls. Comprehensive zoning is often used by local governments to guide growth, manage development, protect natural resources, and achieve community planning objectives. 1. Conditional Public Report. A conditional public report is a document issued by a regulatory agency, typically in the context of real estate development, that provides information about a property or development project to prospective buyers or investors. The conditional public report typically includes details about the property, such as its location, size, features, and amenities, as well as information about the developer, financing, sales terms, and other relevant information. The conditional public report may also disclose any conditions or restrictions that apply to the property or project, such as zoning regulations, environmental requirements, or other legal or regulatory considerations. The conditional public report is intended to provide prospective buyers or investors with accurate and complete information to make informed decisions about the property or development project. 2. Conditional Use Permit. A conditional use permit, CUP, is a type of land use permit that allows for a specific land use or development project that may not be allowed by the current zoning regulations, but is considered compatible with the surrounding area or community under certain conditions. Conditional use permits are typically granted by a local government or planning agency and may involve a public hearing, review process, and specific conditions or requirements that must be met by the property owner or developer. Conditional use permits are used to accommodate land uses or development projects that may not be fully consistent with the existing zoning regulations, but are deemed appropriate based on specific conditions or criteria, such as location, impact on the neighborhood, or compliance with other planning objectives. 3. Conditions. Conditions in real estate refer to restrictions, requirements, or limitations that may be imposed on the use or development of a property. Conditions can be imposed by various entities, such as local governments, regulatory agencies, or private parties, and may be included in legal documents, such as deeds, covenants, conditions, and restrictions, CCR, permits, or contracts. Conditions can vary widely and may include requirements related to land use, zoning, building codes, environmental regulations, financing, or other considerations. Conditions are typically intended to regulate or control the use or development of a property to achieve specific objectives, such as protecting the environment, preserving natural resources, maintaining property values, or promoting public health and safety. 4. Covenants. Covenants in real estate refer to legally binding agreements or promises that are typically included in written documents, such as deeds, contracts, or other legal instruments. Covenants may impose obligations, restrictions, or limitations on the use, development, or management of a property, and they may be created by various parties, such as property owners, developers, homeowners associations, or other entities. Covenants can cover a wide range of issues, such as land use, maintenance, architectural design, use restrictions, or other considerations, and they are typically enforceable by law. Covenants are used to establish rules, regulations, or requirements that are intended to govern the use, development, or management of a property and ensure compliance with certain standards or objectives. 5. Covenants, conditions, and restrictions, CCR. Covenants, conditions, and restrictions, CCR, are legal documents that are commonly used in planned communities, condominiums, or other types of developments to regulate the use, development, and management of properties within the community or development. CCR typically include a set of rules, regulations, or requirements that are binding on all property owners within the community or development and may cover issues such as land use, architectural design, maintenance, use restrictions, assessments, or other considerations. CCR are typically created by the developer of the community or development and are intended to establish a framework for managing the property and maintaining certain standards or objectives. CCR are typically enforced by a homeowners association or other governing body, and violations may result in penalties, fines, or other remedies. 1. Cumulative zoning. Cumulative zoning refers to a type of zoning where the permitted uses of a property are determined by multiple layers of zoning regulations. In cumulative zoning, properties are subject to more than one layer of zoning, such as a base zoning district, overlay zoning district, or other zoning designations, each with its own set of regulations. The regulations from each layer of zoning are combined or cumulated to determine the overall permitted uses, development standards, and restrictions for a particular property. Cumulative zoning is used to address specific land use or development issues, such as environmental protection, historic preservation, or other considerations, and can result in more complex zoning regulations and requirements for property owners. 2. Declaration of restrictions. A declaration of restrictions is a legal document that sets forth certain limitations, requirements, or conditions that apply to the use, development, or management of a property. Declarations of restrictions are typically created by a property owner, developer, or homeowners association and may be recorded in public records, such as the county clerk's office, to provide notice to potential buyers or other parties. Declaration of restrictions may cover a wide range of issues, such as land use, architectural design, maintenance, use restrictions, assessments, or other considerations, and are intended to establish a framework for managing the property and maintaining certain standards or objectives. Declaration of restrictions are typically enforceable by law and may include provisions for remedies or penalties for violations. 3. Development impact fees. Development impact fees are fees imposed by local governments or other regulatory agencies on new development projects to offset the costs associated with the impacts of the development on public infrastructure, facilities, or services. Development impact fees are typically used to fund the construction, expansion, or improvement of public facilities, such as roads, parks, schools, water and sewer systems, or other infrastructure, that are necessary to accommodate the increased demand or usage resulting from new development. Development impact fees are calculated based on the anticipated impacts of the development and are typically established through local ordinances or regulations. Development impact fees are typically paid by the developer or property owner as a condition of obtaining permits or approvals for the development project. 4. Downzoning. Downzoning refers to a change in zoning regulations that results in a more restrictive use or development designation for a property or area. Downzoning typically involves changing the zoning designation from a higher intensity or higher density use to a lower intensity or lower density use, which may restrict the types of uses or development that are allowed on the property or in the area. Downzoning is typically used as a land use planning tool to limit or control the intensity, density, or character of development in a particular area, often in response to changing community needs, environmental concerns, or other considerations. 5. Endangered Species Act. The Endangered Species Act, SAA, is a federal law in the United States that provides protection for endangered and threatened species and their habitats. The SAA is administered by the U.S. Fish and Wildlife Service, USFS, and the National Marine Fisheries Service, NMFS, and it prohibits the taking of endangered or threatened species, which includes harming, harassing, killing, or otherwise harming these species or their habitats, without a permit or exemption. The SAA also requires federal agencies to consult with the USFS or NMFS to ensure that their actions do not jeopardize the continued existence of endangered or threatened species or adversely modify their habitats. The SAA can have implications for real estate development in areas where endangered or threatened species are present, and may require mitigation measures, permits, or other considerations to protect these species and their habitats. 1. Environmental Impact Report. An Environmental Impact Report, EIR, is a document prepared as part of the environmental review process for proposed development projects or actions. The purpose of an EIR is to assess the potential environmental impacts of a proposed project, such as its effects on air quality, water quality, wildlife habitats, noise levels, traffic, and other environmental factors. EIRs are typically required by local, state, or federal regulations and may be prepared by the project proponent or a designated environmental consultant. EIRs provide information on the anticipated impacts of a project and may include proposed mitigation measures or alternatives to minimize or avoid adverse environmental impacts. EIRs are typically subject to public review and comment and are used by decision makers to evaluate the environmental impacts of a proposed project before approving or denying the project. 2. Exclusionary zoning. Exclusionary zoning refers to land use or zoning practices that are designed or have the effect of excluding certain types of housing, typically affordable or low-income housing, from certain areas or neighborhoods. Exclusionary zoning practices may include setting high minimum lot sizes, requiring large setbacks, imposing strict design standards, or implementing other regulations that increase the cost of development or limit the density of housing in certain areas, effectively making it difficult or impossible for affordable or low-income housing to be developed. Exclusionary zoning is often criticized for perpetuating segregation, promoting inequality, and limiting access to affordable housing for certain populations. 3. General plan. A general plan, also known as a comprehensive plan or master plan, is a long-term policy document that guides the physical, social, and economic development of a jurisdiction, such as a city or county. General plans typically include policies, goals, and objectives related to land use, housing, transportation, economic development, public facilities, parks and open space, and other aspects of community development. General plans are typically adopted by local governments and are intended to provide a framework for decision-making related to land use and development over a period of 10 to 20 years or more. General plans are often used as the basis for local zoning regulations, development standards, and other land use policies. 4. Historical designations. Historical designations refer to the recognition or designation of properties, districts, or landmarks that have historical, architectural, cultural, or other significance. Historical designations are typically conferred by local, state, or federal authorities and may provide certain protections or incentives for the preservation or conservation of the designated properties or areas. Historical designations may include designations such as National Register of Historic Places, Local Historic Landmark, Historic District, or other similar designations. Historical designations can have implications for real estate development, as they may impose restrictions or requirements on the alteration, demolition, or development of designated properties or areas, and may also provide benefits such as tax credits, grants, or other incentives for historic preservation. 5. Incentive zoning. Incentive zoning is a planning and zoning approach that provides incentives or bonuses to developers in exchange for specific public benefits or amenities. In incentive zoning, developers are encouraged to provide certain amenities or amenities that benefit the public or the community, such as affordable housing, public open space, transportation improvements, or other community services or facilities, in exchange for additional development rights, increased density, or other concessions. Incentive zoning is used as a way to achieve public policy objectives, such as affordable housing, sustainability, or community development, by leveraging private development to provide public benefits. Incentive zoning is typically implemented through local zoning ordinances or development agreements and may involve negotiations between developers and local governments. 1. Interstate Land Sales Full Disclosure Act. The Interstate Land Sales Full Disclosure Act, ILSA, is a federal law in the United States that regulates the sale of land across state lines. Enacted in 1968, ILSA requires developers or sellers of subdivided land, which includes vacant land or lots for residential or commercial purposes, to provide prospective buyers with detailed information about the property before the sale, including the terms and conditions of the sale, the development plans, and any applicable regulations or restrictions. ILSA aims to protect buyers from fraud and misrepresentation in the sale of land by ensuring that they receive adequate information to make informed decisions about their purchase. 2. National Environmental Policy Act. The National Environmental Policy Act, NEPA, is a federal law in the United States that requires federal agencies to consider the potential environmental impacts of their actions, including proposed development projects, before making decisions. Enacted in 1970, NEPA requires federal agencies to prepare environmental impact statements, EIS, for major federal actions that may significantly affect the quality of the human environment. EISs are intended to assess the potential environmental impacts of proposed actions, including their effects on air, water, land, wildlife, and other environmental factors, and to inform decision-makers and the public about the potential environmental consequences of federal actions. 3. Negative declaration. In the context of environmental review and planning, a negative declaration is a document that states that a proposed project is not expected to have any significant adverse environmental impacts. Negative declarations are typically prepared when a proposed project is determined to have no significant environmental impacts, and therefore no environmental impact report, EIR, is required. Negative declarations may include an analysis of the potential environmental impacts of a proposed project, mitigation measures, and a conclusion that the project is not expected to result in any significant environmental impacts. Negative declarations are subject to public review and comment and may be used by decision makers to determine whether a proposed project can proceed without further environmental review. 4. Non-conforming uses. Non-conforming uses, also known as grandfathered uses, refer to land uses or structures that were illegally established before the adoption of new zoning regulations or changes in land use restrictions, but do not conform to the current zoning or land use requirements. Non-conforming uses are allowed to continue even though they do not comply with the current zoning or land use regulations, as they were legally established prior to the changes. However, non-conforming uses may be subject to certain limitations or restrictions, such as limitations on expansion or modifications, and may be phased out over time or terminated if they are abandoned or discontinued. Non-conforming uses are typically protected by local zoning ordinances and may require special permits or approvals for alterations or changes. 5. Non-cumulative zoning. Non-cumulative zoning refers to a type of zoning regulation that does not allow the accumulation of development rights or density over time. In non-cumulative zoning, development rights or density are typically assigned to a property based on the current zoning regulations and are not transferable or accumulated for future use. Non-cumulative zoning is used to control development and growth by limiting the density or intensity of land use based on current zoning regulations, without allowing for the accumulation of unused development rights or density for future development. Non-cumulative zoning is typically used in areas where there is a desire to limit growth or maintain a certain level of development intensity, such as in rural or environmentally sensitive areas. 1. Partial zoning. Partial zoning refers to a zoning practice where only a portion of a property or a specific area is subject to certain zoning regulations or restrictions, while the remainder of the property or the surrounding area is subject to different zoning regulations. Partial zoning may be used to designate specific areas within a property or a larger zoning district for different uses, densities, or development standards based on specific criteria or conditions. Partial zoning is typically used to accommodate unique or special circumstances, such as areas with unique topography, environmental features, or historical significance, and may require special permits or approvals for development within the designated areas. 2. Preliminary public report. A preliminary public report is a document that is typically required in some jurisdictions in the United States before the sale or lease of subdivided land or condominiums. The preliminary public report provides potential buyers or lessees with important information about the property, including the location, size, design, features, amenities, and legal restrictions of the property, as well as the terms and conditions of the sale or lease. The preliminary public report is intended to provide prospective buyers or lessees with information that can help them make an informed decision about their purchase or lease and is typically prepared by the developer or seller of the property in compliance with applicable state or local laws. 3. Public report. A public report is a document that is typically required in some jurisdictions in the United States before the sale or lease of subdivided land or condominiums. The public report provides potential buyers or lessees with detailed information about the property, including the location, size, design, features, amenities, legal restrictions, financial information, and terms and conditions of the sale or lease. The public report is intended to provide prospective buyers or lessees with information that can help them make an informed decision about their purchase or lease and is typically prepared by the developer or seller of the property in compliance with applicable state or local laws. The public report may be subject to review and approval by a government agency or regulatory body before it can be used for marketing or selling the property. 4. Rezoning. Rezoning refers to the process of changing the existing zoning designation of a property or an area to a different zoning designation. Zoning is a local land use planning tool that designates specific areas for different uses, densities, or development standards, and rezoning can involve changing these designations to accommodate new development proposals, changes in land use patterns, or other planning objectives. Rezoning typically involves a formal process that includes public hearings, review by planning agencies or commissions, and approval by the local governing body or legislative body. Rezoning may be initiated by property owners, developers, or local governments, and may require comprehensive planning, environmental review, and public input to determine the appropriateness and feasibility of the proposed zoning change. 5. Special use permit. A special use permit, also known as a conditional use permit or special exception, is a permit that allows for a specific use or development of a property that is not allowed by the existing zoning regulations, but is deemed to be compatible with the surrounding area and in the public interest. Special use permits are typically granted through a discretionary process that involves review and approval by a local government or planning agency, and may be subject to specific conditions or restrictions to ensure that the proposed use or development complies with applicable regulations and does not have adverse impacts on the surrounding area. Special use permits are typically used to allow for unique or specialized uses, such as schools, religious institutions, or other uses that may require exceptions or modifications to the existing zoning regulations. 1. Spot zoning. Spot zoning refers to the practice of singling out a small area or parcel of land for a different zoning designation or land use regulation than the surrounding area, without a comprehensive review or planning process. Spot zoning may involve granting special privileges or exceptions to a particular property or area, which deviates from the established zoning regulations and may result in inconsistent land use patterns or development standards. Spot zoning is typically subject to scrutiny and may be challenged based on fairness, consistency, and conformity with the overall zoning plan or land use policies. 2. Subdivided lands law. The Subdivided Lands Law is a regulatory framework or set of laws enacted in some jurisdictions in the United States to regulate the sale or lease of subdivided land or properties, such as residential lots, condominiums, or planned developments. The Subdivided Lands Law aims to protect buyers or lessees of subdivided land by requiring developers or sellers to provide certain disclosures, obtain approvals or permits, and meet specific standards or requirements for the subdivision of land. The Subdivided Lands Law may also include provisions for escrow accounts, bond requirements, and other mechanisms to ensure that buyers or lessees are provided with accurate information and adequate protection when purchasing or leasing subdivided land. 3. Subdivision Map Act. The Subdivision Map Act is a state or local law in some jurisdictions in the United States that regulates the division of land into smaller parcels or lots for development purposes. The Subdivision Map Act typically requires developers or property owners to obtain approval for a subdivision map or plan, which includes the layout, design, and development standards for the subdivision, before the land can be divided and sold or leased as individual lots or parcels. The Subdivision Map Act aims to ensure that land divisions are carried out in accordance with local planning and zoning requirements, and may include provisions for infrastructure improvements, dedications of public rights of way, and other requirements to promote orderly and efficient land development. 4. Upzoning. Upzoning refers to the process of changing the existing zoning designation of a property or an area to a higher density or more intensive land use. Upzoning typically involves increasing the allowable density, height, or intensity of development in a specific area or zone to accommodate higher density development, mixed-use development, or other types of development that may be consistent with the local land use policies, planning objectives, or growth management strategies. Upzoning may be initiated by local governments as part of their land use planning and zoning efforts, and may require comprehensive planning, environmental review, and public input to determine the appropriateness and feasibility of the proposed zoning change. 5. Variance. A variance is a waiver or exception from the strict application of the zoning regulations or development standards that are applicable to a property or an area. Variances may be granted by a local government or a zoning board of appeals when strict compliance with the existing zoning regulations would cause practical difficulties or undue hardship to the property owner, and when the proposed deviation from the regulations would not create adverse impacts on the surrounding area or compromise the overall intent of the zoning plan or land use policies. Variance requests typically require a review process that includes public hearings, site inspections, and a determination of the justification and merits of the proposed deviation from the zoning regulations. 6. Zoning. Zoning is a local land use planning tool that designates specific areas or zones for different uses, densities, or development standards. Zoning regulations typically define the types of uses that are allowed or prohibited in each zone, as well as the development standards or requirements, such as setbacks, building height, lot size, and parking, that must be followed for development within the zone. Zoning aims to promote orderly and efficient land development, protect the public health, safety, and welfare, and Unit 14 Escrow and Title Insurance. 1. Abstract of Title. An abstract of title is a written summary or history of all recorded documents and legal proceedings that affect the ownership and transfer of a specific property. It typically includes information about deeds, mortgages, liens, easements, and other encumbrances or restrictions that may affect the title to the property. The abstract of title is prepared by a qualified abstractor or title company and is used by the buyer, seller, lender, or other parties involved in a real estate transaction to verify the current ownership and status of the title to the property. 2. Amendments to escrow instructions. Amendments to escrow instructions refer to changes or modifications made to the original instructions that govern the handling of funds, documents, and other matters in an escrow transaction. Escrow instructions are written agreement between the parties involved in a real estate transaction and the escrow holder, which outlines the terms and conditions under which the escrow holder will act as a neutral third party to hold and disperse funds, documents, and other items according to the instructions of the parties. Amendments to escrow instructions may be necessary to accommodate changes in the transaction, such as changes in the purchase price, financing terms, or other terms and conditions, and must be agreed upon and signed by all parties to the escrow. 3. American Land Title Association, ALTA. The American Land Title Association, ALTA, is a national trade association that represents the interests of the title insurance industry in the United States. The ALTA sets industry standards, provides educational resources, and advocates for the protection of property rights and the efficient transfer of real estate ownership. The ALTA also develops standardized forms and policies used by title insurance companies, including the ALTA Title Insurance Policy, which provides protection to property owners and lenders against defects in the title to real property. 4. Closing. Closing, also known as settlement or escrow closing, is the final step in a real estate transaction where the legal ownership of the property is transferred from the seller to the buyer. The closing typically takes place at a designated location and involves the signing of various legal documents, including the deed, mortgage, and other closing documents, by the buyer, seller, and other parties involved in the transaction. The closing also involves the payment of the purchase price, closing costs, and other expenses associated with the transaction, and the recording of the necessary documents with the appropriate county or municipal office to officially transfer the ownership of the property. 5. Elder abuse law. Elder abuse law refers to a set of laws and regulations that are designed to protect elderly or vulnerable individuals from abuse, neglect, exploitation, or financial fraud. Elder abuse laws may encompass a wide range of conduct, including physical, emotional, or financial abuse, and may be civil or criminal in nature. In the context of real estate, elder abuse laws may be relevant in cases where elderly individuals are targeted or taken advantage of in real estate transactions, such as through undue influence, coercion, or deception. Elder abuse laws may provide remedies, such as civil damages or criminal penalties, for victims of elder abuse in real estate transactions. 6. Escrows. Escrows, also known as escrow accounts or escrow arrangements, are third-party arrangements used in real estate transactions to hold and disperse funds, documents, or other items according to the instructions of the parties involved. Escrows are typically set up by an escrow agent, who acts as a neutral intermediary between the buyer, seller, lender, and other parties, to ensure that the terms and conditions of the transaction are met before the funds or documents are released. Escrows are commonly used in transactions involving the purchase or sale of real property, where they provide a mechanism for safeguarding funds, documents, and other items until all conditions of the transaction are satisfied. 1. Escrow instructions. Escrow instructions are a written agreement between the parties involved in a real estate transaction and the escrow holder, which outlines the terms and conditions under which the escrow holder will act as a neutral third party to hold and disperse funds, documents, and other items according to the instructions of the parties. Escrow instructions typically specify the conditions that must be met for the escrow to be closed, including the delivery of necessary documents, the payment of purchase price and closing costs, and the satisfaction of any other terms and conditions agreed upon by the parties. Escrow instructions are binding upon all parties to the escrow and serve as a roadmap for the escrow process, ensuring that all parties fulfill their obligations and that the trans. 1. Escrow instructions. Escrow instructions are a written agreement between the parties involved in a real estate transaction and the escrow holder, which outlines the terms and conditions under which the escrow holder will act as a neutral third party to hold and disperse funds, documents, and other items according to the instructions of the parties. Escrow instructions typically specify the conditions that must be met for the escrow to be closed, including the delivery of necessary documents, the payment of purchase price and closing costs, and the satisfaction of any other terms and conditions agreed upon by the parties. Escrow instructions are binding upon all parties to the escrow and serve as a roadmap for the escrow process, ensuring that all parties fulfill their obligations and that the transaction proceeds smoothly. 2. Extended coverage policy of title insurance. An extended coverage policy of title insurance is a type of title insurance policy that provides additional coverage beyond the standard coverage offered by a basic title insurance policy. Extended coverage policies typically provide additional protection against risks that may arise after the issuance of a standard policy, such as certain types of encroachments, post-policy forgery or fraud, and other hidden risks. Extended coverage policies may also offer expanded coverage for specific risks or defects, depending on the terms and conditions of the policy. Extended coverage policies of title insurance are typically optional and may be purchased at an additional cost to the basic title insurance policy, providing additional peace of mind to the insured party. 3. Interpleader action. An interpleader action is a legal action initiated by a neutral party, typically an escrow holder or title company, to resolve a dispute between two or more parties who claim to have a legal right to funds, documents, or other items held in escrow or in connection with a real estate transaction. Interpleader actions are typically used when a third party is holding funds or property that is claimed by multiple parties, and the third party seeks to deposit the disputed funds or property into court and have the court determine the rightful owner. Interpleader actions are a legal mechanism for resolving conflicting claims and protecting the neutral party from liability or exposure to multiple claims. 4. Opinions of title. Opinions of title are legal opinions rendered by a qualified attorney or title professional, based on a review of the public records and other relevant documents, regarding the status and condition of the title to a specific property. Opinions of title typically provide an analysis of the legal validity, priority, and enforceability of the title, and may identify any defects, liens, encumbrances, or other issues that may affect the title to the property. Opinions of title are commonly used in real estate transactions as a means of evaluating the quality and marketability of the title, and may be required by lenders, buyers, or other parties as a condition of closing a transaction. 5. Preliminary title report. A preliminary title report, also known as a preliminary title commitment or a title binder, is a document provided by a title company that sets forth the current condition of the title to a specific property as of a specified date. The preliminary title report typically includes information about the ownership, legal description, and encumbrances affecting the property, as well as any exceptions or exclusions from coverage under the title insurance policy. The preliminary title report is typically issued prior to the issuance of a final title insurance policy and serves as a tool for identifying and addressing any potential title issues or defects that may need to be resolved before the transaction can be closed. 1. Rebate law. Rebate law, also known as anti-rebate laws or anti-inducement laws, are laws and regulations that govern the payment or receipt of rebates, discounts, or other financial incentives in connection with real estate transactions. Rebate laws are designed to prevent improper or illegal practices that may influence or manipulate real estate transactions, such as kickbacks, referral fees, or other forms of financial incentives that may create conflicts of interest or compromise the integrity of the transaction. Rebate laws vary by jurisdiction and may impose penalties, fines, or other sanctions for violations. 2. Relation-backed doctrine. The relation-backed doctrine is a legal principle that determines the priority of liens or encumbrances on a property based on the date of their creation or attachment. According to the relation-backed doctrine, liens or encumbrances that are recorded or attached to a property at a later date can relate back to an earlier date, as if they were created or attached at that earlier date. This doctrine is often applied in the context of real estate transactions to determine the priority of liens or encumbrances, such as mortgages, deeds of trust, or other security interests, which may affect the rights and interests of parties involved in the transaction. 3. Standard policy of title insurance. A standard policy of title insurance is a type of title insurance policy that provides coverage for certain risks and defects related to the title of a property. Standard policies are typically issued by title insurance companies and are commonly used in real estate transactions to protect the interests of lenders and property owners. Standard policies of title insurance typically cover risks such as forgery, fraud, undisclosed errors, liens, encumbrances, and other defects that may affect the title to the property. The coverage provided by a standard policy of title insurance is subject to the terms, conditions, and exclusions set forth in the policy. 4. Title insurance. Title insurance is a type of insurance that provides protection against loss or damage resulting from defects, liens, or encumbrances affecting the title to a property. Title insurance is commonly used in real estate transactions to protect the interests of lenders and property owners by providing coverage for certain risks and defects related to the title. Title insurance policies are typically issued by title insurance companies and are based on a thorough examination of the public records and other relevant documents to determine the status and condition of the title to the property. Title insurance policies may be issued to lenders, as lenders' policies, or to property owners, as owners' policies, and the coverage provided is subject to the terms, conditions, and exclusions set forth in the policy. 5. Title plant. A title plant is a comprehensive database or repository maintained by a title insurance company or title abstract company that contains information about the ownership, legal description, and encumbrances affecting properties within a specific geographic area. Title plants are used to conduct title searches and examinations, and to produce title insurance policies and other title-related documents. Title plants may include copies of public records, maps, plats, surveys, and other documents related to real property, as well as historical data and indexing systems to facilitate the retrieval and analysis of title information. Title plants are an essential tool for title insurance companies and title abstract companies in the process of underwriting and issuing title insurance policies. 6. Uniform Vendor and Purchaser Risk Act. The Uniform Vendor and Purchaser Risk Act is a model law developed by the Uniform Law Commission that has been adopted by some states in the United States to govern the rights and obligations of parties involved in real estate transactions. The Act provides rules and standards for the allocation of risk between vendors, sellers, and purchasers, buyers, of real property, particularly with regard to the responsibility for loss or damage to. Unit 15 Landlord-Tenant Law. 1. Assignment. In real estate, assignment refers to the transfer of a party's rights or interests in a property to another party. It typically involves the transfer of a lease, contract, or other legal agreement to a third party, who assumes the rights and responsibilities associated with the original agreement. Assignments are common in real estate transactions, such as when a tenant assigns their lease to another tenant, or when a party assigns their rights under a purchase agreement to a different buyer. Assignments may be subject to certain restrictions or conditions, and may require the consent or approval of other parties involved in the original agreement. 2. Constructive eviction. Constructive eviction is a legal doctrine that occurs when a tenant's right to possess and enjoy a leased property is substantially interfered with by the actions or omissions of the landlord, resulting in the tenant's abandonment or surrender of the property. Constructive eviction may occur when a landlord fails to provide necessary repairs, maintenance, or services that render the property uninhabitable, or when the landlord engages in other acts that make the property unsuitable for its intended use. Constructive eviction may entitle the tenant to terminate the lease, seek damages, or assert other legal remedies against the landlord. 3. Costa-Hawkins Rental Housing Act. The Costa-Hawkins Rental Housing Act is a California state law that governs certain aspects of residential rental properties. Enacted in 1995, the Costa-Hawkins Rental Housing Act limits the ability of local governments in California to regulate rent control and other forms of rent stabilization for certain types of rental properties, such as single-family homes, condominiums, and newly constructed units. The Act also provides for certain exemptions, restrictions, and procedures related to rent control and evictions in California, and has significant implications for landlords, tenants, and local housing policies in the state. 4. Demise. In real estate, demise refers to the transfer of an interest in real property through a lease or rental agreement. It is the act of granting or conveying a leasehold estate to a tenant, who obtains the right to possess and use the property for a specified period of time and under certain conditions. Demise typically involves the creation of a landlord-tenant relationship, with the landlord granting the tenant the right of possession in exchange for rent and other obligations. Demise is a fundamental concept in the law of landlord and tenant, and establishes the legal rights and responsibilities of parties in a lease or rental agreement. 5. Ellis Act. The Ellis Act is a California state law that governs the rights and procedures related to the withdrawal of rental units from the rental market. Enacted in 1985, the Ellis Act provides a legal process for landlords to remove their rental properties from the rental market and convert them to other uses, such as owner-occupied units or condominiums. The Ellis Act establishes certain notice requirements, relocation assistance provisions, and other procedures that landlords must follow when evicting tenants under the Act. The Ellis Act has been a source of controversy and litigation in California, as it balances the rights of property owners with the rights of tenants and the availability of affordable housing. 6. Exculpatory clauses. Exculpatory clauses are provisions in contracts or agreements that release one party from liability or limit their responsibility for certain acts or omissions. In real estate, exculpatory clauses may be included in lease agreements, purchase agreements, or other contracts related to the ownership, use, or management of real property. These clauses may limit or eliminate a party's liability for damages, losses, or injuries that may arise from the property, and may allocate risks and responsibilities between parties. Exculpatory clauses are subject to scrutiny and interpretation under applicable laws, and their enforceability may depend on various factors. 1. Habitability. In real estate, habitability refers to the legal requirement that a rental property must meet certain basic standards of health and safety to be considered suitable for human habitation. Habitability laws vary by jurisdiction, but generally require landlords to provide tenants with a property that is safe, sanitary, and fit for living. This may include providing adequate heating, plumbing, ventilation, electricity, and other essential amenities, as well as addressing issues such as pest infestations, structural defects, and hazardous conditions. Tenants have the right to expect a habitable rental property, and landlords have the obligation to ensure that their rental properties meet applicable habitability standards. 2. Implied warranty. In real estate, an implied warranty is a legal guarantee that is not explicitly stated in a contract, but is presumed to exist based on the nature of the transaction or the relationship between the parties involved. For example, in a lease agreement, there is an implied warranty of habitability, which means that the landlord is implicitly guaranteeing that the rental property is fit for human habitation. Similarly, in a purchase agreement for real property, there is an implied warranty of title, which means that the seller is implicitly guaranteeing that they have good and marketable title to the property. Implied warranties are legally enforceable, and a breach of an implied warranty may entitle the injured party to seek damages or other legal remedies. 3. Lease. A lease is a legally binding agreement between a landlord and a tenant that grants the tenant the right to use and occupy a property for a specified period of time and under certain conditions, in exchange for the payment of rent. Leases are commonly used in real estate to establish the terms and conditions of a rental arrangement, and may include provisions related to rent, security deposit, maintenance responsibilities, repairs, utilities, and other rights and obligations of the parties involved. Leases may be written or oral, but written leases are generally preferred and may be required by law in certain jurisdictions. Leases typically outline the rights and responsibilities of both landlords and tenants, and provide a legal framework for the landlord-tenant relationship. 4. Non-disturbance clause. A non-disturbance clause is a provision in a lease or other real estate agreement that protects the rights and interests of a tenant in the event of a foreclosure or other change in ownership or possession of the property. A non-disturbance clause typically ensures that the tenant's lease will not be terminated or disturbed by a new owner or lender who acquires the property through foreclosure or other means. It may also provide additional rights or protections for the tenant, such as the right to receive notice of any changes in ownership or possession, the right to continue the lease for the remaining term, or the right to seek damages in the event of a breach of the non-disturbance clause. Non-disturbance clauses are often negotiated between parties and may be included in commercial leases or other types of real estate agreements. 5. Periodic tenancy. Periodic tenancy is a type of lease arrangement where the tenant is granted the right to occupy a property for a specified period of time, usually on a month-to-month or year-to-year basis, and the lease automatically renews for additional periods unless terminated by either party. Periodic tenancy is characterized by its indefinite duration, as the lease does not have a fixed end date and continues until properly terminated by the landlord or the tenant according to the terms and conditions of the lease or applicable laws. Periodic tenancy may be created by an express agreement between the parties, or it may arise by operation of law when a lease expires and the tenant continues to occupy the property without a new lease agreement. Periodic tenancy is subject to the rights and obligations of the landlord and tenant. 1. Quiet enjoyment. Quiet enjoyment is a legal concept in real estate that refers to the right of a tenant to peacefully and without interference enjoy their rented property, without being disturbed by the landlord or any other third party. It means that the tenant has the right to use and occupy the rental property without unreasonable disturbance, harassment, or interference from the landlord, other tenants, or anyone else with a legal interest in the property. Quiet enjoyment is typically implied in every lease agreement, and any actions or omissions by the landlord that materially interfere with the tenant's right to quiet enjoyment may constitute a breach of the lease, entitling the tenant to seek remedies such as damages or termination of the lease. 2. Rent control. Rent control is a form of government regulation that limits the amount or frequency of rent increases that a landlord can charge for a residential property. Rent control laws are enacted by local or state governments and are designed to protect tenants from excessive rent increases and provide affordable housing options in areas with high demand and limited supply. Rent control laws may impose various restrictions on rent increases, such as setting a maximum percentage increase, capping the frequency of increases, or requiring justifications for increases. Rent control laws may also include provisions related to eviction protections, lease terms, and other tenant rights. Rent control laws vary by jurisdiction and are subject to specific rules and regulations that landlords must comply with. 3. Retaliatory evictions. Retaliatory evictions, also known as retaliatory actions or retaliatory conduct, refer to actions taken by a landlord against a tenant in response to the tenant's exercise of their legal rights, such as asserting their rights under the lease or applicable laws. Retaliatory evictions are generally prohibited by law and may include actions such as terminating the lease, increasing rent, reducing services, or otherwise harassing or retaliating against the tenant. Retaliatory evictions are considered unfair and may be illegal in many jurisdictions, and tenants who are subjected to retaliatory actions by their landlord may have legal remedies available, such as the right to seek damages, injunctive relief, or termination of the lease. 4. Security deposit. A security deposit is a sum of money that a tenant pays to a landlord or property manager at the beginning of a lease or rental agreement, as a form of financial protection for the landlord against damages to the property or unpaid rent. Security deposits are typically held by the landlord in a separate account and are subject to specific legal requirements and restrictions, such as limits on the amount that can be collected, deadlines for returning the deposit after the lease ends, and itemized deductions for damages or unpaid rent. Security deposits are intended to be returned to the tenant at the end of the lease, minus any deductions for damages or unpaid rent, and are subject to detailed accounting and record-keeping requirements by the landlord. Security deposit laws vary by jurisdiction and landlords are generally required to comply with applicable laws and regulations. 5. Sublease. A sublease is a separate lease agreement that is created when a tenant rents all or part of their rented property to another party, known as the subtenant, for a period of time that is less than the remaining term of the original lease. In a sublease, the original tenant, also known as the subleaser, becomes the landlord to the subtenant, and the subtenant becomes the tenant of the subleaser, with rights and responsibilities that are subject to the terms and conditions of the sublease. Subleasing is subject to the consent of the original landlord, and the terms of the sublease may not conflict with the terms of the original lease. Subleases may be used by tenants who want to temporarily leave their rented property but retain their leasehold interest, or by tenants who want to share the rental cost with another party. 1. Surrender. Surrender in real estate refers to the voluntary termination or relinquishment of the lease or rental agreement by the tenant to the landlord. Surrender may occur when the tenant returns possession of the rental property to the landlord before the lease or rental agreement has expired, and the landlord accepts such return of possession. Surrender may also occur through a formal agreement between the landlord and tenant, where both parties mutually agree to terminate the lease or rental agreement. Surrender may release the tenant from further obligations under the lease or rental agreement, but the specific terms and conditions of surrender may vary and should be documented in writing to avoid any disputes. 2. Tenancy at sufferance. Tenancy at sufferance, also known as holdover tenancy, refers to a situation where a tenant remains in possession of a rental property after the lease or rental agreement has expired, without the landlord's consent. Tenancy at sufferance arises when a tenant fails to vacate the rental property at the end of a lease or rental agreement and continues to occupy the property without renewing the lease or obtaining the landlord's consent for continued occupancy. Tenancy at sufferance is generally not favored by law and may result in the tenant being subject to eviction proceedings and liable for damages caused by their continued occupancy. 3. Tenancy at will. Tenancy at will is a type of leasehold arrangement that allows a tenant to occupy a rental property without a fixed term or duration. Tenancy at will is created through an agreement between the landlord and tenant, where the tenant has the right to occupy the property for as long as both parties agree, and either party may terminate the tenancy at any time without a specific notice period. Tenancy at will is typically used for short-term or temporary rental arrangements and may be terminated by either party at any time, subject to any applicable laws or regulations. 4. Tenancy for years. Tenancy for years, also known as term tenancy or lease for a fixed term, refers to a lease or rental agreement that has a specific duration or fixed term. Tenancy for years is created through an agreement between the landlord and tenant, where the tenant has the right to occupy the rental property for a specified period of time, such as 6 months, 1 year, or any other agreed upon duration. Tenancy for years typically requires the tenant to vacate the rental property at the end of the fixed term, unless the lease or rental agreement is renewed or extended by both parties. 5. 30-day notice. A 30-day notice is a type of notice that is typically required by law in some jurisdictions for certain lease terminations or changes in rental terms. A 30-day notice may be given by either the landlord or the tenant and typically requires one party to provide written notice to the other party at least 30 days before the intended change or termination takes effect. A 30-day notice may be used for various purposes, such as terminating a month-to-month tenancy, changing rental terms or conditions, or notifying of intent to vacate. The specific requirements and legal implications of a 30-day notice may vary by jurisdiction and should be followed in compliance with applicable laws and regulations. 6. 3-day notice. A 3-day notice is a type of notice that is typically required by law in some jurisdictions for certain lease violations or non-payment of rent. A 3-day notice may be given by the landlord to the tenant and typically requires the tenant to cure the lease violation or pay the overdue rent within 3 days, or face eviction proceedings. A 3-day notice is typically a prerequisite to initiating legal action for eviction or lease termination and must comply with applicable laws and regulations, including specific content and delivery requirements. The specific requirements and legal implications of a 3-day notice may vary by jurisdiction. 1. Unlawful detainer action. An unlawful detainer action, also known as an eviction lawsuit or summary proceeding, is a legal process initiated by a landlord against a tenant who is unlawfully occupying a rental property. Unlawful detainer actions are typically used to regain possession of a rental property when the tenant has violated the lease or rental agreement, failed to pay rent, or otherwise breached their legal obligations as a tenant. Unlawful detainer actions are subject to specific legal procedures and timelines, and the landlord must follow applicable laws and regulations in order to lawfully evict a tenant. 2. Writ of possession. A writ of possession is a court order that authorizes the sheriff or other law enforcement officer to physically remove a tenant from a rental property and restore possession of the property to the landlord. A writ of possession is typically issued by the court as a result of a successful unlawful detainer action or eviction lawsuit, after the court has ruled in favor of the landlord and ordered the tenant to vacate the property. The writ of possession provides the legal authority for the sheriff or other law enforcement officer to execute the eviction and remove the tenant from the property. The tenant is usually given a specific time frame to vacate the property voluntarily before the writ of possession is enforced.